what's been happening in the Supreme Court. Now, one of the big talking points of the last few months was an order that came in from the top court issuing a deadline to governors and the president for assent to bills. Now, President Murmu has raised big constitutional questions over this directive. In a rare and significant move, President Murmu has sought clarity from the Supreme Court over its authority to fix deadlines for constitutional authorities like the president and governors to grant assent to bills. President Murmu, invoking a seldom-used constitutional provision, has referred 14 pointed questions to the Apex Court, effectively challenging its jurisdiction in the matter. And among them is a central query. Can the Supreme Court direct the president or governors to act within a specific time frame? And there's no time frame given in the Constitution. Remember, the top court order had set a timeline for governors and the president to act on state legislation in action that sparked a major debate on the separation of powers. So let's tell you exactly what this letter is all about. Why did the president send off a letter to the Supreme Court? This comes because the top court a few months ago set a time frame for precedent guidelines for bills passed by assembly. So essentially they said no pocket veto or absolute veto available to president under Article 201. So it's mandatory, according to the Supreme Court, for the president to make a choice between the two options available and then to go ahead and respond. The president should either grant assent or withhold assent to a bill. So they've said that you can't hold on to a bill forever, either let it pass or don't let it pass. Now, the bill constitutional authority can't exercise powers arbitrarily as well. And this was a strong comment that came in from the Supreme Court, where they essentially pulled up the governors as well as the president, saying that you can't go ahead and use your powers to hold on to these legislations, to these bills. The Supreme Court has said withholding assent under Article 201 to be accompanied by furnishing of reasons as to why it's being held back. And they said the time frame, that's the most important aspect here, where the Supreme Court said that a decision must be taken within 3 months. So they issued a deadline to the governors as well as the president. The top court said that if it goes beyond 3 months, reasons must be conveyed to the state directly. This was the verdict that came in on April 8th, based on which the president has said, when the Constitution doesn't mention any sort of time frame, how can the top court go ahead and say it? Now, the timeline essentially that's been given is for the governors, where reserving bill for the president with aid and advice of Council of Ministers must happen within 1 month. Withholding assent without aid and advice of Council of Ministers means that they must return the bill in a matter of 3 months. All of this mandated by the Supreme Court. Now, a bill presented after reconsideration by State Assembly, then there has to be assent, and the assent must be given within 1 month. This is what the top court ruled, over which President Murmu has shot off questions now to the Supreme Court.